Okay, Michael, over to yourself.
Very good. Thanks a million, Martin. As I said, it's been okay. Good evening, everyone. I recognize one or two of you guys, Valerie and Geraldine. How are you doing?
Good, thank you.
How are you, Michael?
Hi, Geraldine. Good to meet up with you again. And good evening to Paddy. Is it David?
Yeah.
And John from Creasla as well. Is that right?
Yeah.
How you doing, guys? Okay. I just thought that maybe we might just refresh a few things for you, because I'm sure you probably have gone through a lot of this thing before. And there may have been some changes, so I'll bring you up to date on that. So what I was planning to do was to go through contracts of employment and spend a bit of time as well just looking at the grievance procedure and the disciplinary procedure, and looking as well at dignity and respect at work, which really covers the whole area of bullying and harassment. The Organisation of Working Time Act, which covers break times, it covers annual leave, covers all that good stuff. Performance management, looking at it from an employee perspective as well, and then looking at it from the Workplace Relations Commission if you were to have an inspection, which could possibly happen at any time. And there'd be an opportunity as well for you to have any questions and answers that you may have. Now, that's what I have in the presentation, but can I say if some of that is not particularly relevant to you, we don't have to stick to the script. This presentation, I think there's 56 slides in it, and I have committed to forwarding on the presentation to Martin, and he in turn, if any of you want a copy of the presentation, he'll gladly email it out to you as well. Is that fair enough?
Okay.
Yes.
Okay. So at any stage that you want to stop me in my tracks, or you have any questions, specific questions, I'd only be too happy to answer those questions for you. Is that all right?
Yeah.
Okay. So we're just going to look at the employment contract first of all. Do all of your staff, I understand that you are either a chairperson or you're a secretary or you're a treasurer in working on a voluntary basis with your different managers. Do you all have contracts of employment?
Yes. Yeah.
Okay. Is that a unanimous? Yes, it is.
We're redrafting ours, Michael, at the moment.
Okay, right, Valerie. Okay, so contracts of employment, there's two pieces of legislation. One is the Employment Information Act and the other is the Protection of Employees Fixed Term Working Act. And there are also clauses as well to be included in any written statement that is governed by the Unfair Dismissals Act and the Minimum Notice of Terms of Employment Act. Now that's a bit of a mouthful, but really what it's saying is that any of your staff have a right to be issued with a contract of employment. And ideally, when you're appointing someone, you should send them a job offer letter, and accompanied to that should be a contract of employment. And the contract of employment only becomes effective then when they sign and return their contract. Okay. So the written statement, you have to give it within 5 days of commencement of their employment. However, new employees must be provided with a copy of the disciplinary process within a month of commencing of employment. So in some instances, you may have a situation where none of your staff have got contracts of employment, but you now have to issue them, or you have to revise them as well. What's hugely important there, and I think this applies, I think, to yourself, Valerie, and to Geraldine, if you are revising the contracts, that it's done in consultation with the staff as well. So, for instance, you cannot unilaterally come along and change anyone's terms and conditions of employment unless you get their agreement to those changes as well. Is that fair enough? I presume you're just updating the contracts to reflect the current legislation. Is that the case?
Yes.
Yeah, and there's no material changes to their hours of work or to their rates of pay or to anything like that, is there?
No.
No. Okay. But you get the point that
Yeah.
if there are any changes, then you can only have those changes included in the revised contract with their acquiescence and agreement as well. All right. Okay, so any existing employees, and I know this is not the case, but any existing employees who may not have a contract of employment but request one, then you have to give them a written statement within 2 months of that request as well. All right. I think what's important is there is a legislative requirement to provide contracts of employment, but I always draw the analogy of the written contract of employment to the prenuptial agreements. So if you have tens and tens of millions in the bank and you're getting married, invariably you will want to sign a prenuptial agreement. And that's if anything happens to the relationship, that it's clear who's going to get the summer house or who's going to get the yacht or who's going to get whatever. That's not a great way to start off a marriage, but it's the reality. So the contract of employment is a little bit like that as well. What's far, far more important than the actual contract of employment is the relationship that you have with each and every one of your staff. That to me is so important. And that's not in any way to diminish the importance, the contractual requirement that you have to issue them with a written statement of their terms and conditions of employment. So the 5 core terms, then you have to include their names of the employer and the employee, the address of the employer, the expected duration of the contract. Is this a fixed term contract or is this a contract of indefinite duration? Is it permanent? The rate or method of calculation of pay and the number of hours the employee is reasonably expected to work per normal working day, per normal working week. So is it a 35-hour working week? Is it a 7-hour working day? Whatever the case may be, that you have to stipulate as part of the 5 core terms. Okay. Again, can I encourage you to stop me at any time if there's anything that I'm not making clear to you? Is that all right? So in a written statement of the terms and conditions of employment, you can see it's much more comprehensive. Again, the name and the address of the employer and the employee, the place of work, the title or the nature of the job itself, the date of commencement of the employment. For temporary contracts, the expected duration. So is this a fixed term contract for 6 months or for 12 months, whatever the case may be, and the date on which that contract will expire in a fixed term contract. The rate or method of calculating the employee's remuneration and the pay interval. So is the pay going to be weekly or monthly? Is it going to be by check or electronic transfer? Any terms or conditions relating to the hours of work, including overtime. So I'm not sure if overtime is a factor in any of your organizations. But if it is, do you pay a premium for anyone that works past their normal working hours? It may be that you give them time and a half, or it may be that you give them double time if they work so many hours on a Sunday, whatever the case may be. Any terms and conditions relating to paid leave other than paid sick leave. Now, just to be mindful that there is statutory sick leave coming in, but it's still only at the bill format at the minute, but it will become law in 2023. Any terms and conditions relating to incapacity for work. So if anyone was sick, what is the obligation on that individual in terms of reporting their absence from work or their sickness or whatever? And usually what you would typically say there is that you expect that the individual will inform you within the first hour of the commencement of work at the very latest, and you also should insist as well that they will submit a medical certificate within the first 3 days of their absence as well, and that they will continue to produce medical certificates on a weekly basis. And again, that would be important as well. And any terms and conditions relating to pensions or to pension schemes as well. So in some you have to make available to individuals, if they want to take on a personal retirement scheme as well, PRSA. You have to allow them the opportunity to explore that with 2 potential providers as well. The period notice that the employee is required to give and to receive. So under the Minimum Notice in Terms of Employment Act, if someone is in your employment for more than 13 weeks and less than 2 years, they're entitled to 1 week's notice or 1 week's payment in lieu of notice. If they're in your employment for more than 2 years, but less than 5, they're entitled to 2 weeks notice. 5 to 10, it's 4 weeks notice. 10 to 15, it's 6 weeks notice. And anyone that's in your employment for more than 15 years under the Minimum Notice in Terms of Employment Act, they're entitled to 8 weeks notice. All right. Now it may be that in your contract of employment, you might say, well, look, the notice period that we expect from you is that you give us 4 weeks notice. Okay. So if they intend to leave your employment, then that's the notice period that they will give you. Oftentimes it may be the case that they're going to another job or whatever, and it would be, although it's in the contract of employment, it would be very, very difficult to insist that person would actually work out their full notice. And sometimes you might be better off that they just leave within, a mutually agreed time as well. I've put in there number 11, which is may or not be relevant, but if there are any collective arrangements that directly employs the terms and conditions of employment, can I take it that none of the staff that you have are members of a trade union?
No,
Yeah. No, we're not.
yeah, they're not.
No. Okay. So number 11 isn't relevant there, but if you had your staff represented by a trade union, invariably you would have what's known as a collective agreement, so that you would be negotiating the terms and conditions of employment with the trade union, and who represent the staff. All right, so that's not relevant. So what is advisable to include in the written statement of terms and conditions of employment? You have to include a probationary period. And usually, when you offer a job offer, it's conditional upon that individual passing a probationary period, usually for 6 months. Now, can I just say that the number of times that we get employers phoning into us and saying, look, I have a problem employee and he or she is in my employment for 7 months or for 8 months or whatever. And, we invariably said, well, look, did you have a probationary period? They will say, yeah, we had. And I said, well, did you not use the probationary period to see that this individual can do the job, is doing the job, is a good fit into your team, and has potential to help you to develop and grow your organization? And really, it's surprising the number of employers that don't use that probationary period. And after the 6 months, they end up with someone that they find very difficult to get rid of. So I would actively, if you're ever in this situation, to make sure that you have a probationary review after 2 months and after 5 months, and that you can put your hand on your heart and say, yes, this person is someone I'm very confident and comfortable in giving a permanent contract of employment. All right. In terms of annual leave and public holiday entitlement, typically, how many hours do your manager and your cook, how many hours do they typically work in a week?
24 in our case.
24, okay.
Yeah, 21.
21, okay.
Yeah.
Okay, and how do you currently calculate their annual leave entitlement?
We have a treasurer who works that out. It's in the contract and all. So
Okay. If staff work less than 1,365 hours in the year, then their annual leave entitlement is calculated on 8% of the hours that they actually work. All right. And you know as well that there is public holiday entitlements as well, and you have got 9 public holidays. And there's another public holiday it's going to come into effect in 2023 as well. And obviously the public holidays then will be on a pro rata basis. I know one of the questions that Martin anticipated would be that you might have is that, let's say for funding purposes that you close down for maybe a couple of weeks during the summer, can you stipulate that the staff have to take their annual leave during that period? And the answer is absolutely you can. Absolutely. If it's your policy that you close down for 2 weeks, then you can say up front, look, for the first 2 weeks of August, we close down, and therefore 10 of your 20 annual days annual leave will be for that period.
Mhm.
Likewise, at Christmas time as well, you invariably will be closed over Christmas, New Year period, and you may want to allocate 3 or 4 days annual leave there as well. And then that would leave the individual then with discretionary 5 or 6 days that they can take throughout the year.
Mhm.
Is that okay?
Yeah.
Now, compassionate leave is not a legal requirement. However, you know, and I know that if a staff member has a bereavement of a close family, that they need, time off work with pay, over their grieving period. Invariably, it would be 3 days for someone who's a close relative. That might be a spouse or a partner, or a mother or father, brother or sister, son or daughter. If it's maybe an uncle or an aunt, it's usually 1 day. It's compassionate leave. In Boyd HR, we don't stick to that. What we say in Boyd HR is, look, if you have a bereavement, of one of your family, just come to me and we'll agree on a period. We had one staff member that lost her sister, and she got 2 weeks compassionate leave, with full pay, because she was very close to her sister, and it was shock, and that was the right thing to do. But there's no legal entitlement to compassionate leave. Force majeure leave then is a statutory entitlement. And force majeure leave is that if there is an emergency in the family and your staff member is the only person that can deal with that emergency, then that person has an entitlement to 3 days paid leave in a year, or 5 days paid leave over a 3-year period. All right. But again, it has to be an emergency, and it has to be that individual is the only one that can deal with that emergency at that given time as well. Maternity leave then, that an employee is entitled to 26 weeks maternity leave, and they may apply as well for additional maternity leave as well. The maternity leave it's very protective, in that, the individual going off should expect that she can return back to her job that she left before she went off maternity leave under the exact same terms and conditions of employment. Layoff and or short-time working, again, you never know what might crop up, but you need to have a clause in place that in the event of, let's say, there being a downturn in the economy, or that there's a fire in the building, or whatever the case may be, and that if you don't have this stipulated in your contract of employment, that you have the right to pay people off on a temporary basis, then effectively you can't, unless it's in your contract of employment. Or if you have to reduce for funding purposes, if you have to reduce their working hours, again, it's very important that you have that clause in your contract of employment as well, that allows you to put your staff on short-time working. Right of search is something that is more relevant maybe to people that are working in retail. You would be surprised at the amount of theft in workplaces, and it would be, as a result of the staff working within the place as well. Dress code and hygiene, again, it's important. Occasionally we would get a query, how do you deal with an individual because his or her personal hygiene isn't what it should be, and there's an odor and it's causing upset to fellow employees as well, or indeed that they don't necessarily present in a clean and neat and tidy way as well. So again, it would be important that you state up front, look at, here's the particular dress code that we have working in the organization. Again, confidentiality is important, you know, that you want that, you know, the staff are not talking about matters that are maybe commercially sensitive or of a personal nature, whatever the case may be. You know, it's important that you have a confidentiality clause. On the basis that your staff are working maybe 22, 23, 24 hours, it's very important that you have a clause in there as well around double employment, because under the Organisation of Working Time Act, staff should not be working in excess of 48 hours in a week. So if you had someone that's working for you for 23 hours in the week, and they happen to have a job outside of your employment, and that the additional hours, you know, are in excess of 48 hours, then that's an issue. All right, so it would be very important that you would have that in the contract of employment as well, that whatever work that they're doing, on the basis that it's not in conflict with your employment, and that you are the primary employer, then from a health and safety point of view, they should never be working in excess of 48 hours. Any questions on that? Because there's quite a bit in that.
Just on that, on the double employment, do you need to, is there a sort of a standard paragraph that can be included, like, or to do that?
Yes, Paddy, there is, absolutely. And, you know, what we can do is we can give you wording on that if you thought that was useful.
Mhm.
Yeah, absolutely.
Yeah.
And in fact, Paddy, we would even go one step further. There's a form that you would have the staff member complete as well, you know, and just to that you would have the record to satisfy yourself that they're not working in excess of 48 hours. That would be
Okay.
important to have on file. Yeah.
Thank you.
Michael, is there a standard clause for force majeure and layoffs and short-term working?
Absolutely, Valerie. Yeah, yeah. And again, what I can make available through Martin is those clauses for you. I can give you a standard contract of employment if you thought that was useful. That would
Yeah,
include
just
all of these.
That'd be good, yeah.
Yeah, absolutely, not a problem. I'm at an age now, if I don't take it down, I won't remember it. So just
we're all at that age.
okay. I've just taken a note here to forward on a draft contract of employment to Martin. Is that all right?
And does a right of search have to be in it?
No, not at all, Valerie. No.
That's good.
I was just saying that would only be maybe in retail.
Retail.
Yeah.
Okay.
Yeah. Now I know I used to work donkeys years ago down in County Clare, and in Shannon, there was a company there called De Beers. It was a South African company, and they used to polish the diamonds that they were mining in South Africa. And clearly, you know, you couldn't have staff going out in the evening time with a pocket full of diamonds. So clearly there was a right of search there, you know. So, I mean, that's a bit ridiculous, but that was the case. No, but absolutely, Valerie, there's no compulsion to have that statement in there.
Okay.
So again, the written statement must be signed and dated by or on behalf of the employer, right? Now that's important, that there is no statutory requirement on the staff member to sign the contract of employment. All right. In fact, we're dealing with a case at the moment where staff member is refusing to sign the contract of employment, and that's fine. But what you could do then is that you could issue that person with a letter, and the letter would state that, you know, for compliance purposes, that you have been issued with a contract of employment, and that you have received it, and that you are refusing to sign it. That's fine, because if you had an inspection from the Workplace Relations Commission, you can then satisfy that inspector that you are in compliance and that your staff have been issued with contracts of employment. All right.
But if they refuse to sign it, they're still entitled to a copy of it, obviously.
Oh God, yeah, you would give them a contract of employment.
But
yeah,
they're not,
absolutely.
but they don't have to sign it.
But they don't have to sign it. No, Valerie. No. Now, just another point as well, that if you issue a contract of employment, and in that contract of employment will have the terms and conditions of employment that you are offering, and they refuse to sign it, and you know, if within a month there is no objection to any of the terms and the conditions that are contained in that contract of employment, they have what is known as, they have acquiesced to those terms and conditions. So they have agreed to those terms and conditions of employment. All right. So for a contract to exist, there's 4 elements to it. One is there must be a job offer. 2, there must be a job acceptance. 3, there must be what's known as a consideration. So in other words, you pay the individual for the hours that they're working. And the last one is that the intention must be to create a legally binding arrangement between the parties. So they're the 4 terms that have to exist. If those terms exist, then there is a contract of employment. All right. And the employer obviously is required to retain a copy of the statement, and the throughout the employee's employment and for 1 year thereafter. So, you know, if an employee leaves your organization, then, you know, for 12 months thereafter, you retain a copy of that contract of employment as well. And after that, then you can shred that contract of employment. There's no need for it in terms of requirements. Employers must not make subsequent changes to the employment contract. So that's what I was just saying to you. Once you issue a contract of employment and it's signed by the individual, you cannot change any of those terms and conditions without first consulting with the employee and obtaining their acceptance and acquiescence to that change as well. All right. Now, can I just give you maybe an exaggerated example of what I'm saying there? So, for instance, if you were to increase that person's hourly rate of pay, you know, in line with the changes to the what to, I have a mind block now for a second, but the minimum payment, what do you call it?
Minimum wage.
Minimum wage. Yeah, thank you. Thanks to my friends out there. To the minimum wage, it would be good practice just to give that employee an addendum to say, look, you are on this rate, you are now on this rate. And a copy, and they have them sign that off as well. And a copy of that goes on their employee file as well, because it is effectively a change to their terms of employment. All right. And all changes to the original contract must be in writing and signed and dated by both the employer and the employee, with the exception of the employee who may, you know, have an issue with signing it as well. Now, I just say it doesn't apply, but maybe it might apply to other organizations that maybe aren't present this evening. But you can appreciate that if someone is in employment, say for 10 years, and you as a committee decide, well, you know what, we have an obligation now to make sure that all of our staff have got written statements of the terms and conditions of employment, and you are now presenting this contract of employment. I mean, invariably what will happen is the employee will say, look, I've worked here for the last 10 years without a contract of employment. Why are you giving me this piece of paper to sign now? It's inevitable that there will be an element of suspicion in it. So I think what's important to state there is, well, you know what, this is a legal obligation that we have as a board to ensure that the staff have got the contract of employment in place. And just to note as well that there are 9 inspectors down in Sligo that work for the Workplace Relations Commission, and their sole remit is to go around organizations to ensure that every organization is in compliance with the raft of legislation that's out there. So we would typically have 1 or 2 business owners every week, contacting us and saying, look, we've got notification that there's a WRC inspection coming up in 2 weeks' time. What do we do? You know, and so the first thing you have to do is make sure that all the staff have got contracts of employment, and that you have you know, timesheets to ensure that you're in compliance with the Organisation of Working Time Act as well. And I'll come to that in a few minutes. But where an employer fails to provide a contract of employment to staff, potentially, now this is worst case scenario, but potentially they could face a fine of €1,200 for each breach of contract. So you can see it's very sizable. But now I have to say we work quite closely with the Workplace Relations Commission, and they're... Sorry, John. Were you saying something, John, there?
No,
No, sorry, John. I thought you said.
no, I was speaking to my wife. She came into the room. Sorry.
Okay.
Sorry about that now, Michael.
Don't use no need whatsoever. So the Workplace Relations Commission, I have to say that they're very reasonable individuals, and they will do their best to help organizations to be in compliance. But we have had 1 or 2 employers that, you know, were resisting being in compliance with the legislation, you know, and their powers are quite wide ranging. They can refer the matter to the district court for enforcement. That's not an area you might necessarily want to go down, you know, but that's worst case scenario. Any questions on contracts of employment?
Yeah, just before you move on, Michael, can I just
Yes, Martin.
clarify from a query from another organization? So if, for example, you've had your supervisor or cook working in the centre for a considerable number of years, but they've never had a contract of employment,
Yeah,
and now that committee are issuing a contract of employment, but the person then we'll just give this scenario that you said there, but maybe they're a bit skeptical or weary of
Yeah.
it, and they don't sign it. The committee then would issue a letter stating
Yes.
that we've issued you with a contract, but you refuse to sign, and we have a copy on file or something like that.
exactly.
Okay, thank you.
Yeah, and that suffices. Yeah. Now, what we do is...
Sorry, Michael,
Yes,
can I ask?
John. Yes, John.
We've somebody working for 20 years, over 20 years. And over the last 3 years, we've become the, you know, part of the charity thing.
Regulation.
Yeah,
Which
the
is start
charities
drawing
regulator.
which is start drawing up all the policies. And, you know, partaking in policy drawing up and all of that was not part of the contract 20 years ago. And we would need to negotiate that with them to bring them forward to do that. Is that what you're saying?
Well, no, that's more, John, a change to their job description, really, isn't it? I mean, what they were employed to do currently, they're now involved in drawing up policies
Yes,
in compliance with the Charities Act.
charity regulators.
Yeah, charity regulations. Well, that's not a change to the terms and conditions of employment. That's a change to their
Okay.
job description.
Okay, so the job description can change.
Oh God, yeah. You know, I mean, the reality is, there's change happening all around us,
Mhm.
and you know, if you go back to the dinosaurs, it was their inability to adapt to the change in the environment that led to their extinction. So, you know, we all have to change. You know, change
Yeah.
is a constant. You know, and
Um,
Charlie.
you know, in relation to that, John, it's a huge task for your supervisor cook to take on. I would feel can I say from our own day centre, you know, our supervisor said to me, but that's not my job to do. No, she wasn't asked to do it. I was looking actually for the policies that were there. And, you know, because of them being out of date. And I would feel it's not her job to do.
Do you want me to respond to that, Geraldine, directly?
Yeah.
Yeah, okay. Just so that you know, as an employer, as board members, you know, where you stand on this whole area. There's only two things that as an employer, you can't ask an employee to do. You can't ask an employee to do something clearly that's unsafe. Equally, you can't ask an employee to do something that's unlawful. But after that, you have the right to ask them, in the expectation that they will carry out your instructions, whatever you want them to do. Because the Irish law is based on the old English law of the master-servant relationship. All right. Now, going back to maybe writing up policies, you know, the individual might feel, well, God, you know, this is beyond my ability or my scope of practice, or whatever the case might be. You know, you would then have to think in terms of, well, is this a reasonable request of this individual or not? And what I hear you saying, Geraldine, it's not reasonable, maybe, for that particular individual. But I think the important point being that, you know, you have the right to ask that person to do that job. And maybe they need additional training, maybe they need a bit of coaching, maybe they need whatever. But as an employer, under employment law, you have the right to insist that they will do it. And failure of an employee to carry out a reasonable, and I put the emphasis on reasonable, a reasonable instruction is what's known as insubordination. And insubordination is invariably gross misconduct. Okay, so if I was to ask one of my team to carry out a task and I felt it was reasonable and they refused to carry it out, you know, I would insist that they would carry it out. I would give them 10 or 15 minutes to reflect on the seriousness of refusing to carry out the instruction that I'm after giving them. And I would also say to them as well, look, I want you to carry out this task, if necessary, to carry out this task under protest. And the very fact that you're asking someone to do something that under protest, that automatically invokes the grievance procedure. So after they have completed the task, then they have the right to raise the grievance that they had with respect to that particular instruction that you're after insist that they would do. Now, that's a bit of a mouthful, isn't it?
Michael, can I ask you something? You
Valerie.
see, when you're giving out, if you're updating contracts for a staff member,
Yeah.
is it best practice to give them to update their job description to make sure that they know exactly what's required of them?
Yeah, absolutely. One of the things that we're going to come to, time permitting, Valerie, is the whole area of performance management. And the very basis of performance management is that the individual knows exactly what it is that you expect from them in terms of both their performance and their behavior. So yeah, it's the very beginning of good performance management, that they know clearly. And this goes back again to, you know, at interview stage, you know, that there's absolute clarity. Look, this is what this job entails. And typically on the best day working here, this is what you will be involved. But equally on the worst day working here, this is typically what's involved. So that the person can make an informed decision. Yes, I'm comfortable in taking on this role. And it's very important that it's written down so that there is no ambiguity afterwards. And I think what's very important as well is that you would have the last line of entry in the job description and carry out any instructions, any other instructions that you're given.
And can you ask them to sign the job description as well as the contract?
Absolutely, 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 absolutely.
That's fine.
Absolutely.
Okay, thank you.
Can I ask you something,
Yes,
Michael,
Yeah,
in
sure.
relation to that last statement about to carry out any other instructions?
Yeah, as required. Yeah.
How broad and how narrow?
As
that?
broad, Geraldine, or as narrow as you want it to be, or as you need it to be. But again, can I just say, we're just looking at this tonight purely from an employment legislation, but I think what's equally important as well is to look at it from an employee relations point of view as well. You know, so what you want to have is you want, you know, I'm often asked, how should you treat your staff? And the answer is, to me, very simple. You should treat your staff as if you had a son or a daughter working in the organization, and how you would want them to be treated.
Mhm.
You know, because what you want at the end of the day is you want the staff to feel, you know, safe, number one, and you want staff to feel valued and appreciated as well. Because inevitably, I mean, what we come across is that, you know, staff will usually be able to justify their wage at the end of the week with given about 60% effort. But there's 40% there that is untapped. And oftentimes employers, you know, never tap into that discretionary effort. And that discretionary effort has to be won. You can't command it. It has to be won. And it can only be won by, you know, creating an environment where people want to give of their best. And unless and until, you know, you treat your staff with respect and with dignity, and you're helping them to develop and grow personally and professionally, you never can win that discretionary effort. And that's such a loss. Does that make sense?
Yeah.
Yeah, absolutely.
And, you know, we're not now looking at grievances. Now, if this is not relevant, please, I can move on to other parts as well. But you know, and I know that no matter how good a relationship is, there will be issues will arise from time to time. All right. And same is true in the working relationships as well, that there will be from time to time occasions when, you know, maybe someone has got an issue or a concern. So where an employee or a group of employees perceive a problem or grounds for complaint or dissatisfaction with the company, that's why you have a grievance procedure in place. So for instance, I have come across situations where an individual, you know, had an issue with her manager and raised the grievance and nothing was done, and then raised that grievance then after about 2 weeks with that manager's manager and nothing was done. Went to HR in that particular organization and nothing was done. All right. And eventually went to the managing director in that organization and was more or less, you know, just dismissed, you know, didn't entertain the grievance at all. Now that person ultimately had to resign her position from the organization because to continue to work in that organization was injurious to her health and well-being. That individual was able to take a constructive dismissal case against the organization and won it and got a very, very large sum by way of compensation. So what's important is that if a staff member raises a grievance, that it is incumbent upon the manager or maybe you as board members to ensure that that grievance is resolved at the earliest possible opportunity. So typically in a grievance procedure, you know, it's stating, well, look, if you have got any gripe whatsoever, we need to hear about it. And we need to hear about it as soon as possible so that we can resolve the matter. All right. I remember donkeys years ago over in the States. I was at a workshop, and the title of the workshop was, it was only a half-day workshop, but the title of the workshop was "Elephants Don't Bite." And the first question that was asked, I'm going to ask you the same question: have you ever heard of anyone bitten by an elephant?
No.
No.
No, because the reality is elephants don't bite. But you know, and I know that, you know, it's the mosquitoes, and it's the ants, and it's the ticks, and it's the wasps and the bees. It's all the small things that cause all the pain and all the irritation.
Yeah.
So it's small issues that cause the pain and the irritation in the workplace as well. And that's why it's so important that you have a process and a procedure in place, that if a staff member has got any issue whatsoever, that they know that they have the right to raise that issue in the expectation that that issue will be resolved as quickly as possible and at the lowest level possible, and that it's not allowed to fester. Does that make sense?
That doesn't need to be in as part of the contract. No, just has to be under the grievance policy.
Well, Fanny, what we would suggest that attached to your contract of employment, you would have 4 policies and procedures, and one would be the grievance procedure. It's that important. One would be your disciplinary procedure, because if you can remember back, you know, if you're only obliged to provide a written statement of their core terms within the first 5 days of their starting work, but you're obliged to give them a contract of employment within the first 2 months of their starting work. But you're also obliged to provide them with a written statement of their disciplinary procedure within 1 month of their starting. So we would say include in your contract of employment 4 appendices, one being your grievance procedure, the second one being your disciplinary procedure, the third one being dignity and respect in the workplace, which is all around, we'll come to it, it's all around how do you prevent bullying and harassment and sexual harassment in your workplace as well. And the last one then is all around the use of the internet and the mobile phones. Because, you know, you want to have a policy in place whereby there are individuals and that they're not accessing, you know, websites, you know, that are inappropriate websites. Or, you know, we had a situation once where an individual working in a financial advisory company, and she sent out very, very offensive emails to a number of the key clients of this organization, and by email. And you know, clearly that was a very serious matter. But if you didn't have a policy in place to say that that was wrong, you know, you're up. That's funny. Okay, so the basic principles then is it is a procedure for resolving any issues that are there. Try and settle it as quickly as possible and at the lowest level possible. And what's very important as well is like our own personal relationships as well. You know, what do you say? The advice that you get is never sleep on a row, you know, and try and you know, you have to preserve the relationship. And it's a commitment to the procedures by all parties. No industrial action until procedures are exhausted. I mean, we had one organization that were non-unionized, and the grievance remained unresolved. And the matter then was referred to the Workplace Relations Commission, to the mediation services there as well. But you don't want that matters are referred to a third party. You know, you'd want that they're resolved internally. And again, I made reference to that you can insist that someone will conduct something if necessary under protest as well. So when you ask someone to do something under protest, it automatically means that they can invoke the grievance procedure immediately following completion of the task. You okay with that?
Yep.
So it's good practice, in other words, to have a grievance procedure in place, because inevitably issues will arise, and you want to have a way for dealing with those issues speedily and satisfactorily as well. So there's just some tips there. I'm not going to go through them, but for instance, you know, if you try and resolve the grievance and you're unsuccessful, then you know that they can appeal that to the next level in the organization, or maybe to the chairperson of the board, whoever the case may be. And it would be important as well to keep minutes of the meetings as well. Why do you think it's important to keep the minutes of the meeting?
So that you know exactly what was said and discussed and agreed.
Yeah. Or if subsequently they were to say that, look, at my grievance was ignored, you know, well, you can refer back to the minutes of the meeting and, you know, how was said and how was done. Yeah, absolutely. Okay. So I'm just going to skip that for a second. Okay. This is if a grievance remains unresolved, it can be referred to the WRC. They will appoint an adjudication officer. And if there's no satisfaction at that stage, then that matter can be referred to the Labour Court. So it's getting very serious at that stage. Clearly, there's a breakdown in the employer-employee relationship. But it happens. I mean, there's one case that we are dealing with, and we had to refer the matter to the adjudication officer of the WRC because there was no talking to this individual. She was just really entrenched in her own position. So the matter will be referred to an adjudication officer in the WRC, and that adjudication officer then will make a determination on the matter. Okay, the next area is, and again, can you give me a bit of feedback as to how relevant this is or is not for you, where you may have to challenge someone's poor performance or correct their unwanted behavior?
Mm-hmm.
Is it relevant?
Yeah.
Yes.
Okay. Great stuff. We prefer to call it the corrective action procedure or process rather than the disciplinary process, because the disciplinary process is very what we call parent-child type relationship. So the corrective action process, there's I suppose 5 stages in it, but you use the corrective action process when someone maybe is not performing at the level that they should be, or maybe not behaving in a manner that you would want them to be as well. And there's different stages that you go through as well. So if someone isn't performing, you know, you just have a word with them, and it's the first stage, which is counselling. And you explain to them, look, we're unhappy with your level of performance, or in, the way you're behaving is against our policy, and you need to be aware of it and to do something about it. But if the poor performance or the unwanted behavior was to continue, then you may have to progress down the disciplinary process, and it could be the outcome might be a verbal warning, a written warning, a final written warning, and ultimately dismissal as well. But you're only ever having to dismiss someone as the very, very, very last resort. You clearly, you don't take away a person's livelihood lightly, or you should never take away a person's livelihood lightly as well. So what happens at each stage? So the first instance where you're counselling the person, it might be for first instance of poor performance or minor misbehaviour. So you advise the employee of the poor performance or the misbehaviour and inform them of the required standard. You explain that failure to meet the required standard within a defined time period will result in further corrective action. So you put in the instance of poor performance, you put a performance improvement plan in place, and you're stating really, look, at this is your performance is at this level, but we need it to be at that level. The responsibility is yours to bridge that gap in performance levels within a month, maybe, or 6 weeks. And as an employer, you just look to see, well, what can we do by way of support to help you to bridge that gap in performance? So that's the first stage. But if that isn't effective, so there's no sustained improvement in performance, then it will be the case then that you may have to go on to the next stage. And the next stage is where you have to deal with this person on a more formal basis. Now, if I heard, if I had hot dinners for every time I heard an employer saying to me, well, I gave that person a verbal warning, I'd be very comfortable. I mean, you cannot issue someone a verbal warning. You have to go through a process. And are you familiar with that process, or do you want me to just maybe explain it somewhat?
Can you explain it?
Yeah, perfect, Paddy.
Okay.
So, for instance, you would have to formally, write out to the individual and invite them into a formal disciplinary hearing. That person would be entitled to be accompanied by a fellow employee at that meeting as well. And you would have to put, what the issue is to that person. And you would have to offer them the right of reply to what it is that you're saying. And you would then be expected to give consideration then to their reply. And you then decide, do I accept that or not? And then, you then would issue whatever your decision is, and your decision might be, well, you know what? You've already gone through the counselling and it hasn't worked. And now your performance is still at substandard level. And I am left now with no alternative but to issue you with a verbal warning. And the verbal warning is issued in writing. And that the person has to know that this verbal warning will last on their personnel file for 6 months. And unless and until there's sustained improvement in that person's performance, you may have to further invoke the disciplinary process to the next level, which would be a written warning, final written warning. Does that make sense here? So the whole idea of the disciplinary process is not to slap someone across the wrist, but it is just to impress upon them the seriousness that you are attaching to, be it the poor performance or be it the unwanted behavior as well. That's not acceptable. And that as an organization, you cannot and you shall not accept that standard of performance or that unwanted behavior. Okay. Now, you also have to offer that person the right. So your decision is, I'm going to issue you with a verbal warning and I'm communicating that to you in writing. And this is a formal warning and to last on your personnel file for 6 months. But you have to offer that person the right to appeal your decision as well. And that appeal has to be by someone who has had no involvement in the disciplinary process up to that stage. Does that make sense? It has to be independent. All right. I'll give an example. We dealt with a case many years ago where it was this petrol pump attendant, and he had a habit of maybe not giving the change back to the customer that came in looking for a fill of diesel or petrol, whatever the case may be. And initially he was cautioned on it, and the procedure was that should a driver, accidentally drive off without getting their money, the procedure was you handed that into the cashier and you explained the situation, and then when the customer came back, then went to the cashier and the change was handed over. But this individual had a pattern of not doing that, so he had to go through after the counselling, he went through the disciplinary process and he went through the verbal warning, a written warning. It happened again. He was on a final written warning. And lo and behold, this day, a teacher pulled up and she wanted €20 of diesel. And she handed in €50 and she drove off because she was rushing to school. And the individual, didn't hand in the €30 change. And he was invited into the disciplinary meeting again. And clearly at this stage, he couldn't offer any reasonable explanation as to why he went against the policy and hadn't handed in the €30 change. And this was before lunch, so he knew that he was going to face, dismissal. However, the owner of the station had to give due consideration, and so he said, "Look, I'm going to adjourn this disciplinary hearing now, and I'm going to reconvene it again after lunchtime." And so the individuals noted what was going to happen, or anticipated what was going to happen, and he said, "Look, I don't want to be fired because I don't want that would damage my reputation. Why don't you write out a resignation letter and I will sign it?" So the employer thought, "Oh God, this is great. It'll save me having to terminate this guy's employment." And he duly had a resignation letter signed or written, typed out, and your man signed it. And this was at 2:00 in the afternoon, and it was on a Friday afternoon. And he continued working at the station until 4:00, which was his finishing time. And he went around to all his colleagues and he said goodbye to them, and that he was resigning and he was getting a job elsewhere. And the following Monday, he initiated proceedings with the Employment Appeals Tribunal at the time, claiming that he was unfairly dismissed. So the employer, thought he had all of the documentation in place and everything was done procedurally correct. But when it came to the Employment Appeals Tribunal hearing, he claimed that the employer forced him to sign a resignation letter, and that the employer had called him a tinker and a scab and everything else. And that guy got an award of £8,000 at the time, pounds at the time. So what's hugely important is, if you have a disciplinary procedure in place, let's go back to the point you were making earlier, Valerie, it's so important to have all of the documentation in place so that you can show to an independent adjudicator that you did everything procedurally correct. Procedurally correct. Right?
Sorry.
Sorry, go ahead.
I just want to ask you there, Michael, when you talk about having documentation, does that mean that the meeting that you would have, the recordings of the meetings that you would have, would be kept on that person's file, or is there another file that you would create?
No. Absolutely, Charlie. It has to be on that person's personnel file.
What has to be in their personnel file?
Yeah.
Okay.
Now, what's equally important as well, Geraldine, is, let's say that the person is given a verbal warning and the duration of that verbal warning is for 6 months. What's hugely important is that after 6 months that you go and you take all reference to that verbal warning out of that person's personnel file, and that you treat that individual as if he or she never had that verbal warning.
Mm-hmm. Okay.
They're entitled to go back again to, ground zero.
Yeah.
No, but it has to be in their personnel file. And, an individual can take a claim for unfair dismissals for up to 6 months. All right. And in certain circumstances, up to 12 months. Okay. And again, our experience is that if you go before the WRC, if you go before an adjudication officer, it's like a football match. Before you kick a ball at all, you're automatically 2-0 down. Because the legislation, as it's titled, it's called the Unfair Dismissals Act. Yeah. So the starting point before a Workplace Relations Commission is that you have unfairly dismissed this individual. And it is up to you as an employer to prove that you dismissed this person fairly.
Mm-hmm.
And unless and until you can show, and that you have documentary evidence to show that you have done everything 100% correct, that you've adhered to your own procedures, and you've applied the laws of natural justice, you'll lose the case. Sobering. So I'm just going to just
Retiring.
I'm just going to go through this here for a second. So just go back. Sorry, I'm just jumping this for a second. I'll come back to you. Yeah. So the laws of natural justice, this is what's important here, is a person has the right to know what is the allegation against them. So what is it that they allegedly have done wrong or didn't do, whatever the case may be. And then at a formal disciplinary hearing, they have the right of reply. And then they have the right, as I said, to be accompanied by a fellow employee, or the right of representation. Equally as well, if the facts aren't known, then they have the right to a fair and impartial investigation as well. And they have the right to fair determination. So in other words, you know, the punishment has to fit the crime. So, you know, if someone does something and it's misconduct, but it's not gross misconduct, then that warrants, it doesn't warrant that person will be terminated.
Yeah.
And the last thing as well is that they have the right to appeal as well. And as I said, whatever your decision is, whether it's, you know, you're going to issue a person with a final written warning, or you're going to terminate their employment, or whatever the case may be, that's your decision. However, that person has the right to appeal that decision to someone else that hasn't had any hand, act, or part in that decision up to that minute in time.
And sorry, Michael, I just have a question in
Yeah,
relation.
sure.
If you have somebody employed and you have what did you call the first section? You know, where a probationary period.
Yes.
And you don't employ that person, do you have to give them a reason why?
Oh, yeah. So you employ someone on a probationary period, Charlie.
Yeah.
Maybe he or she is not working out. Is that the case?
Yeah. Yeah.
Yeah. Well, again, you know, the test always is, what would a reasonable employer be expected to do under the same set of circumstances? So, for instance, if you had an individual and he or she is given a contract of employment and they're on the probation for the first number of months, then, you know, you have to do everything in your power to help that person to be successful in the role. So that's why you have, inevitably, you will have a very good induction program in place, you know, so that they know at the outset, look, this is the standard of performance that we expect from you. This is the standard of behavior that we expect from you. Here's the training we're going to give you. We're going to formally sit down with you after 2 months and after 5 months, and we're going to make a determination, you know, are you fit for the job or not? Are you a good fit into the team? And, you know, it would be very important that you would highlight any concerns that you have with that individual, and give them an opportunity to address those concerns. But, and again, it'd be very important to have all of this documented as well. But if you have any reservation whatsoever, you know, I would always err on the side of caution, and I would not pass that person's probationary process, and that I would not issue that person with a contract of indefinite duration. And, you know, the contract of employment that they have signed, because the job offer is conditional upon their returning the contract of employment, and the contract of employment inevitably will state that termination of employment within the probationary period, the Unfair Dismissals Act does not apply. So you have the right to terminate that person's employment, you know, during the probationary period, but you have to ensure that you've given that person every opportunity to address the shortcomings that they may have in terms of their performance. You know, and that's what a reasonable employer would do in any case.
Mm-hmm.
Does that answer your question?
Yeah. Thank you.
Yeah. But there should be no surprises at the end of the day, you know. The individual should know, look, clearly my employer is not happy with, my performance, whatever the case may be. Okay. Happy enough with that?
Yes.
I would say that at least 90% of all cases that fail and that are the determination is in favor of the employee is because the employer has not adhered to their own procedures. So if you have a procedure in place, you have to adhere to that procedure step by step. And you have to afford the rules of natural justice that you have there before you as well. And if you don't do that, you have lost the case before you ever go into a WRC hearing. And the 3 remedies for an unfair dismissals case is they have the right clearly to compensation, and that compensation can be up to 2 years' salary. The other 2 remedies then is either reinstatement or re-engagement. Now, in the past, there was a huge backlog of cases, under the Unfair Dismissals Act, and sometimes it could have taken maybe 6 to 9 months before a case would have been heard. And if the determination was reinstatement, it meant that the employer had to back pay that person for the 9 months from the time that they made the complaint, and also that take them back into their original job as well. So you can imagine, as an employer, if you attempted to terminate someone's employment and the decision was, well, no, you have to take that person back into your employment. If they were difficult beforehand, there'd be you wouldn't want that. But inevitably, you will agree to some form of compensation, but stakes have gone up considerably. Okay. Now, sorry, any questions? I'd love to think I'm making it very clear. What's hugely important is that you have a policy on dignity and respect in the workplace. And let's go back to the point you were making, Valerie. It should be one of the 4 policies that you have as an appendix to the contract of employment as well. Because there is an obligation on employers under the Health, Safety and Welfare at Work Act to provide a safe place of work. But there's also an obligation on employers as well to ensure that there is no bullying or harassment or sexual harassment in the organization as well. So there's a definition that's widely accepted as to what is bullying, and it is something that's repeated and it's inappropriate behavior. It's either direct or indirect. It's either written, verbal, physical, or otherwise. It's conducted by one or more persons against others, another or others, at a place of work and in the course of their employment, which could be reasonably regarded as undermining that individual's right to dignity at work. Okay, that's the definition of what bullying is. So you can see that it is not a one-off thing, but it's something that is repeated. So it happens over a period of time. It's inappropriate behavior. In other words, the behavior is wholly unwanted by the recipient, and it has the effect of undermining that person's sense of self-worth and their self-dignity as well. And it's during the course of the employment at their place of work. And I've come across individuals who have been very, very badly bullied. Their whole sense of self-confidence, self-worth is just shattered, and it should never ever be allowed, so it's very important that where there are instances of bullying or harassment, that they're stamped out straight away. Otherwise, you know, if it's not dealt with, you know, the culture in the place will become toxic. And, you know, you get a reputation out there for being a place, you know, who would want to work in that place, because, you know. So your responsibility as committee members under the Dignity Respect at Work is to ensure that there is a policy, that it is implemented, and that your direct reports are aware of that policy. So what's good practice is for all of your policies, let's say that you have regular meetings, let's say monthly meetings or fortnightly meetings with your manager. That would be very important to take out a policy as part of the meeting, take out a policy and just go through it with that person. So, you know, constantly you're going through all of the policies, and that you have a record that you've gone through that policy as well. And that you demonstrate personal commitment to equality, that you role model appropriate behaviours as well. You know, this notion, can I trust your handshake? You know, do you talk the talk or do you walk the talk? Do you know what I'm saying to you?
Yeah.
That you promote equal opportunity and diversity awareness through appropriate meetings and training. That you're very vigilant of the behaviour of individuals within their teams. That you're responsible for addressing actions which might cause offence. That where there are allegations of bullying, that you have that investigated. That you take appropriate action then. That might be in using the disciplinary process. And then you take all practical steps to ensure that the employees feel valued and realise their potential as well. That's hugely important. So it's important that you have a policy in place. It's very important that you circulate that policy. It's important that you have your employees sign off that they have both read and understood that policy as well. And that in your dealings with everyone, you treat them fairly. You encourage individuals, look at, if they feel that they are being targeted and that they feel that they're being bullied or harassed, that it is their responsibility to make you aware that this is going on, so that you in turn can do something about it as well. And that any incidents that are reported, that you treat those incidents as being serious. In other words, that you have it investigated. Now, the Organisation of Working Time Act, that sets out standards in relation to time spent at work. So under the legislation, we talked about it earlier, but employees are not permitted to work more than 48 hours in a 7-day period. Now, usually you might have spikes at work as well. And maybe that over any 1 week that maybe staff have to work in excess of that 48 hours. But the reference period is for 14 weeks. So as long as the average doesn't exceed 48 hours over a 14-week period, then you're okay. And it's also important as well to know that they're entitled to rest periods of 24 consecutive hours in any 7-day period, as well as 11 hours rest in every 24-hour period between shifts as well. Okay, so if your staff are working from 9 to 5, you're 5 days a week, or whatever the case may be, or they're working 9 till 12 or whatever, you're well within the obligations of the Organisation of Working Time Act. What is important as well is that you afford staff proper rest breaks. So if they're working for more than 4.5 hours, they're entitled to a 15-minute rest break. If they're working for more than 6 hours, they're entitled to a 30-minute rest break, and that can be combined with the 15-minute earlier break as well. So the Organisation of Working Time Act also addresses premium pay for Sunday working, public holiday benefits, and annual leave entitlements as well. Going back to our WRC inspector, they will want to know that you are in compliance with the Organisation of Working Time Act. So unless and until you have got timesheets, you know, that shows the individual's start time and their finish time, and that shows that if they have an entitlement, if they're working in excess of 4.5 hours, that they're getting their 15-minute break, you won't be able to show the inspector that you're in compliance with the Organisation of Working Time Act. So, do you have timesheets in operation for your staff?
I
Yes,
think so, yeah.
we're working on it, yeah.
Yeah.
I think our supervisor has a timesheet, yeah.
Yeah. Again, it's very important because I remember being before an employment appeals tribunal years ago, where the manager of a hotel, the relationship went sour with the owner of the business, and he was the person previously who was responsible for the rostering of staff and the allocation of work and everything else. And when the relationship went south, he took a claim against the employer. And one of the claims that he was making was that he was working in excess of 48 hours and he wasn't getting his rest breaks and all that good stuff. And, you know, the employer's argument clearly was, well, look, if you were responsible for the roster, you should have factored in your own rest breaks and that you weren't working excessive hours. The chairperson of the Employment Appeals Tribunal took a totally different view and said, no, it isn't the manager's responsibility. It is you, the owner, who had responsibility for the manager. The manager was responsible for the staff. So you as a committee have responsibility to ensure that your manager is, making sure that they have got their proper rest breaks and that they're not working excessive hours. So it would be good practice to have timesheets that staff complete and submit on a weekly basis and that they're signed off. Also, as well, it's important. I mean, how do you demonstrate that you have given your staff their annual leave entitlement?
Well, it's documented in the minutes of our meetings that the staff are off. I'm not sure if there's a timesheet kept by the supervisor on that, but it's documented. It is just discussed at the meeting that the centre is closed and they're off on holidays. Is that sufficient or?
Yeah, what I'd advise there, Geraldine, would be, well, look, can I say it's far better than having nothing. What we would advise would be that you have holiday request forms.
Okay.
So it's a form that they will complete to say, well, look, I want to go on annual leave from this date to this date. And you have to decide then whether or not, for operational reasons, whether you can afford that person that annual leave at that period or not.
Yeah.
Invariably, you'll be able to accommodate it, but and then you sign off on that annual leave request that you have approved it. And then you keep a copy of that on file as well, because that's what an inspector will look for when they come in to inspect, and that's the only way you can show that you're actually in compliance with the Organisation of Working Time Act and specifically their annual leave entitlement. They'll also look as well, do you keep pay slips?
Yeah, whoever does this, and our treasurer does the pay slips.
Okay, that's very important as well. And then the pay slips should show that they're getting paid for their annual leave, but that they're also being paid as well for the public holidays as well.
Yeah.
Yeah, that's important. Okay.
Michael, should you have a template on file like we used to have in the bank, where you had a holiday sheet for each staff member and you put their entitlement at the top, and then when they took a day, it's taken off the total with what they have left at any given time?
Exactly, Valerie. Yeah, that's what I'm talking about. The annual leave request form that we have just does exactly that. So to start off year January 1 with or January 2 with an entitlement, and then as they take their annual leave days, then it's tallied up. Yeah.
But are you talking about a request form if they're looking for leave separate to the one that keeps a record of what they've taken?
Well, no, the annual leave request form that we have would say, look, at the beginning, this is your entitlement. For our senior staff, we they work full time, so they are entitled to 25 days annual leave plus the 9 public holidays. So just states at the very, very beginning, look, at this is your annual leave entitlement, and then as they request the annual leave, then part of the form is, when this is the hours, this is the number of days we have remaining as annual leave. So you have a record there all the time. And that's signed off and that's approved, and then they take it and then they're paid for it.
Do you
So
see
that's
as well, I know we're going back for 1 second, do you see your dignity and respect policy? Is there a template for that?
There is a policy on it, yeah. Of
Any chance we can get a copy of it?
course you can. Yeah, absolutely.
Okay.
And also maybe the sort of time sheets that may be used, like, you know, for.
Yes, Paddy, yeah, absolutely, will do. Absolutely. So that's the policy on dignity and respect for. Can I just take it that I'll issue drafts for everyone on the dignity and respect as well, not just yourself, Alvy. But
Yeah.
would you like it as well, Paddy,
Yes, yeah.
John, and David?
Yes.
Yes, please.
Perfect.
If you feel like issuing it on the 4 of them, Michael, would be even better.
God, she drives a hard bargain, doesn't she? Huh? Of course, absolutely. I'm only joking. Of course, yeah, of course, absolutely. Now, can I'll send it out as a draft, so you can tailor it specifically to your organizations. Is that all right?
Great, lovely, thank you.
Yeah,
Yeah, perfect. Okay. So an organization can receive notification of an inspection to be carried out on their premises by the Workplace Relations Commission adjudication, so at any stage. And typically we will get calls, you know, at least once or twice every week of an inspection, you know, that's about to take place. During an inspection, the adjudication officer may request documentation to prove that the organization is in compliance with the Organizational Working Time Act. Heavy fines can be imposed, and as I said, the maximum fine that can be imposed is €1,200 for each breach of contract. And if the employer's responsibility to demonstrate their compliance with the Act regarding staff rest periods and breaks. So as long as you have the documentation in place, you know, it's a breeze, you know, these inspections, but where you don't have them, you know, that's when it's difficult. So that's just around attendance and time. Is attendance and timekeeping, are they issues that you have, or are you? No issues?
Oh, not really.
Okay.
no, but we have it in the contract. There is a reference to,
Yeah.
you know,
yeah.
their frequent lateness, you know, and all that.
Yeah. There's a misunderstanding by some employees that they feel that if they're submitting medical certificates, then that they can't be touched. Can I just say that a medical certificate explains why a person isn't at work, right? But very importantly, it doesn't excuse that person not being at work. And there's a very important distinction there. Because implicit in everyone's contract of employment is that they will attend work on a regular and dependable basis. Okay. And if someone, you know, over a long period of time, and when I say a long period of time, if after 6 months, this person is unlikely to be coming back to work now or in the foreseeable future, that person is potentially in breach of contract. And you can lawfully terminate that person's employment.
After how long?
Well, it's typically how long is a piece of string, Valerie, and I don't mean to be glib in giving that answer, but usually, you know, after 6 months, you know, you would have to be seriously asking, what's the likelihood of this person
Return to work.
being able to return to work now or in the foreseeable future on a sustainable basis? Because remember, and I'm not sure an awful lot of employers really understand this, but if an individual is out and they're producing medical certificates on a weekly basis, then they are entitled to accrue their annual leave as if they were at work.
Yeah.
So there's a cost there to you as an organization to pay them their annual leave. And that's 1 point, if for someone that's working on a full-time basis, that's 1.66 days per month,
Mhm.
you know, and if they're out for a period of 15 months, that's a lot of time. So I think it's incumbent upon the employer to, you know, encourage people, you know, to come back to work. Now, that's only on the basis that you know, and you would typically invite them, look at, in conjunction with your own doctor, can you please nominate a date that you're likely to return to work in the near future, you know?
Are you entitled to ask them if they've been out for a couple of months to provide a fitness to return to work form or cert from your doctor?
Or you have to insist on it, Valerie.
Yeah.
Yeah, absolutely. I mean, I would say anyone that's out for more than 2 or 3 weeks,
Yeah.
that
get
they
that.
should submit, you know, that they're fit to work again. Exactly. Now,
Is that, sorry, Michael,
Yeah,
you
sorry,
know,
Fran.
when you get your final cert, you have to get a final cert to return to work. Is that what you mean? Is that,
yeah.
does that say fitness? Is that?
Oh, yeah, same thing. Yeah, absolutely. Now, if it's a thing that there's no likelihood of someone being able to come back to work now or in the foreseeable future, what would be, and clearly they're going to be in breach of contract, what's hugely important is that you have got up-to-date medical opinion upon this person. So you can't rely upon maybe an opinion, medical opinion that you got 6 months ago. It has to be up to date. And invariably what we would do in that case is we would refer a person to an occupational health physician, because the occupational health physician, his or her medical opinion outweighs that of a general practitioner, because they are general practitioners, but they do a 2-year advanced course in occupational health as well. And they will issue a report, and, you know, clearly they will state, you know, whether this person is likely to come back to work now or in the foreseeable future or not, you know. But at least, you know, once you have a definitive statement saying this person is unlikely to be able to return to work now or in the foreseeable future, then you can lawfully terminate that person's employment on the grounds of incapacity to do the job that they were employed to do in the first case.
And that's in private workplaces. You can do that, Michael.
Or you can do it anywhere, Geraldine. Yeah.
Right. Yeah.
Yeah.
Well, I was aware of it in the public sector, but I actually.
Oh, in the private, absolutely. Yeah. Because
Yeah.
it goes back again to what I was making earlier. Implicit in everyone's contract of employment is that they will attend work on a regular and dependable basis. So clearly, if someone's out on long-term absence and there's little or no likelihood if they're able to return to work now or in the foreseeable future, they're in breach of contract.
Okay.
And on that basis, then you can lawfully terminate that person's contract. Now, that's not to prevent anyone that from taking a claim for unfair dismissals. I mean, they can claim, well, look, I've been unfairly dismissed, and that's fine. That then goes before an adjudication officer of the WRC, and they will hear both cases and they will make a determination. But again, you know, on the basis that you have got the most up-to-date medical opinion on this person and his or her likelihood of being able to come back to work, and on the basis that the report is clearly stating there is no likelihood or very little likelihood of this person ever been able to come back to work within the next 6 months or 3 months, whatever the case may be, you can lawfully terminate that person's employment. Okay. If someone is persistently coming in late to work as well, I mean, that's a matter that should be dealt with under the disciplinary process as well. You know, what I find as well is most problematic is intermittent absences, where, you know, someone is missing a day here and missing a day there. And the difficulty is it's very hard to plan, you know, around someone not knowing whether they want to be at work or not. If someone happens to be, you know, out because they're hospitalized because they have an appendix, you know they're going to be out for 2 or 3 weeks. You can plan around that. But it's nearly impossible to plan around whether a person is going to phone in and say they're not coming into work today because they've got whatever. Does that make sense?
Mhm.
And that's what the disciplinary or the corrective action process is for. So under the Organisation of Working Time Act, you have to know what employees are entitled to, and you know You have to ensure the employees are receiving their entitlements. You have to record the employees' start, finish, and break times each day, and be able to demonstrate your compliance. And the easy way around that is that you have got that annual request form that I was recommending to you. That's for the annual leave. Now, I'm very conscious that we're past the time. And you're all, as Martin said at the very beginning, you're all volunteers and you're giving up your own time. Are there any questions that you want to ask?
Well, just one question, Michael, on
Yes,
the,
Paddy.
you mentioned at one stage that you have to offer, or there's something about pensions.
Oh, yeah.
Is that what does the employer, do we, as an employer, do we have to to offer the people the entitlement, you know, like to look into their own pensions, or
Yeah.
do we have to provide people that will advise them, or?
Yeah, no, Paddy, your only obligation is that you afford your staff the opportunity to look at a private pension.
Mhm.
So typically, you would have someone maybe over at Glenties who's a financial advisor, and he or she will come in and just maybe explain, well, look, here's what you can do by way of, you know, making your own contribution to a personal pension plan. But there's no obligation on you as an organization to provide any contribution towards or having a company pension scheme.
Yeah.
No obligation, no.
Okay, thanks. That's great.
And again, that will be a standard clause that we'll include in the contract of employment as well.
Mhm.
The PRSA. Sorry.
Yeah.
And definitely we'll exclude the right of search because that's not relevant. People could take exception to that as well. The other thing as well is if your premises is if you have CCTV for security reasons, whatever else as well, it would be important that you would include that as well. And that CCTV could be used for disciplinary purposes. May or may not be relevant, but if it's not in there, you can't use it, you know. Okay, look, there's more in the presentation, but I'm just mindful of the time. I'm happy enough to stay on, but it's up to yourselves.
Michael, can I just go back on a point?
Sure, Charlie.
You know, in relation to the policies and us asking about, you know, the supervisor or the cook doing the policies.
Yes.
The properties are HSE day centres. I have actually written to the HSE in relation to policies for day centres, because we're all trying to do there's an awful lot of work involved in it.
Sure.
And I have brought it up recently that I feel, you know, day centres like nursing homes, hospitals, you know, must have some type of policies that would be helpful to us. Now, I have got a favourable reply in the sense that there is a new older persons services manager appointed, and the person, our point of contact, is going to make contact with them in relation to the matter, because I just feel I'm not sure that actually the supervisor would be capable, not in an intellectual way, but in the requirement of what a day centre should have.
Sure.
And that there should be somebody, and there must be somebody in the HSE that does that type of thing.
Sure.
And that we then maybe can tweak the policy to suit the individual situation. Like, for example, our day centre is only used by the day centre committee.
Sure.
You know, whereas maybe other centres have a health centre attached or included or whatever.
Sure.
So that's where I was coming from.
Yeah,
And
no, perfect.
You
No,
know,
yeah.
it's not that our supervisor would downright blatantly refuse
Of
or anything,
course, no,
but it's you know, it's the knowledge of what needs to go into these policies
sure.
Exactly.
that you know, I would be a bit concerned about.
Yeah, no, that's fine. And look at, again, going back to the old measure, what would a reasonable employer expect under the same set of circumstances? And clearly, it would be unrealistic to expect that, you know, your manager would be able to draft policies and areas that they have no, you know, they've no experience in. or
Yeah,
No, that wouldn't be reasonable. That'd be very unreasonable.
yeah,
No.
yeah.
Yeah, but then the other side of the coin there is, Michael, the people who are volunteering to get this governance off the ground, we're expected to get them all up and running, these policies,
Yeah,
you know, and we're not experts in this field in any shape or form.
I know.
Yeah.
And do you know what? I take my hat off to you guys, because, you know, it's tough, and there's huge obligations on your shoulders as well.
There is, and if anything happens or goes wrong, we're the
Yeah.
fall guys.
Yeah. And look, I'll be more than happy to forward on a draft contract of employment and templates for the for policies and procedures and the annual leave request form and whatever else is in the notes. You know, but just suffice to say that, you know, I'll be saying, look at, you know, before you issue a contract of employment, that you need to get, you know, your own advice that it is compliant, you know.
Mm.
And, you know, yeah, okay. Did you find this useful?
Yeah.
Oh,
Very
great.
useful.
Good,
Yeah,
good,
Very
good,
good, very good.
good stuff.
And
All
thanks.
right. Martin, is there anything that you want?
No,
just wrapping up?
thank you, Michael, and I hope everyone has got benefit of the session. I know we ran slightly over, but and as Michael says, there's a whole lot more there too. But I just to go back on Geraldine, your last comment there too, where I think too you can be referring to some operational matters as well as I'd say if they kind of the employment policies that Michael's talking about tonight. So in terms of operational policies, by all means you can try and get some from the HSE, but we also would have in the LDC, we would have some templates that we would use for community centres and social enterprises and for community groups that we can look and see what's appropriate to maybe what you need in terms of that operational aspect, and we can help in that regard, myself, Margaret and Lourdes. So, you know, if there is any, sorry, not just Geraldine, anybody there in the network, that if you feel that you're, for example, volunteer policy or you know, whatever, you know, safety issues and so on. So if there's anything there that you want to ask us for, we will try. Like that's non-employment related. We can try and help in that regard. So yeah, is anyone else got any?
Can I just ask Michael one thing? Do you see, Michael, the notice period?
Yeah.
Can you, if you're sending through stuff, can you just elaborate on that a little bit in some form
Sure, yeah.
for putting it into contracts?
Or it would be in it, Valerie.
Right, okay, it's in your
You know,
standard.
that
Okay.
we will stipulate, you know, the notice period under the minimum notice in terms of employment act.
Okay, that's
Yeah,
fine.
that's
All
detailed.
right.
Mm.
Thank you very much, Michael.
Not at all. Hi, Margaret.
Hi, Michael.
How are things?
Not too bad. You're
Good to see
doing
you.
very well there. You're playing a blinder out in it.
Just very happy to be able to help in any way. All right.
Yeah.
You're doing it's great. You know, it's all on a voluntary basis and it's commendable.
Absolutely.
Commendable.
Yeah.
So, yeah, look, if no one's any other questions for Michael, we can wrap it up there, and I will forward on the templates that Michael gives to us.
Yeah.
And as I said, if there's any other queries in between, you can get in touch in your respective area, either to myself or Margaret. we can help where we can. Michael, thank you so much for
Not at all.
tonight's
Pleasure.
session.
Thank you, Michael.
I think just from listening to, you know, everyone had questions, which was good. So it's hopefully everybody found benefit of it, and we'll see you all very shortly at our next network meeting again. So
Okay,
listen, good night, and
thank you very much.
thank you.
Yeah,
Take
thanks
care.
very much.
Thanks,
Michael.
everybody, for